Welcome, everyone. This is the kind of effect that my voice has on my children. They completely ignore it. So, if I can have everyone's attention, we're going to get started on today's wonderful program. Thank you all so much for coming to this extraordinary celebration of the 60th anniversary of the Civil Rights Act of 1964. I'm Jocelyn Samuels. I have the privilege of serving as the vice chair of the EEOC, and I'm thrilled to be a part of this celebration, which EEOC is co-hosting with the Department of Education's Office for Civil Rights and the National Records and Archives Administration. As I know you all are aware, it was a year after the March on Washington when Congress passed the landmark Civil Rights Act, which President Lyndon B. Johnson signed into law on July 2nd, 1964. And I hope you all had the opportunity to see the actual law with the president's signature outside in the lobby. Among other things, this historic legislation outlawed discrimination in employment, education, public accommodations, and federally funded programs. As we celebrate today, it's important to take stock of where we've been, where we are now, and where we still need to go in the continuing struggle for equal rights and equal justice in America. We've certainly come a very long way from segregated lunch counters and schools, poll taxes, and whites-only job postings. And the Civil Rights Act has lowered barriers for dozens of communities, including people of color, women, religious minorities, and LGBTQI+ people. But we're far from finished. While the most blatant forms of discrimination may be less frequent today than they were 60 years ago, we're faced every day with the continuing effects of discrimination in our workplaces, our schools, our housing, in voting, and in criminal justice. We must all, everyone in this room and our allies in the world, come together to address this reality through vigilant and proactive efforts to ensure that the diversity of this country is represented in all aspects of society and that equality of opportunity is truly available to all. You're going to hear from wonderful speakers today. Unfortunately, Mr. Dion Diamond, a freedom rider who was going to participate in a fireside chat with us this morning, was unable to join us due to health reasons. I am told that he will be fine, and also, serendipitously, that he will be celebrating his birthday on July 2nd, which is the very day that the Civil Rights Act was signed. So I know you join me in sending our best wishes to him for a full and speedy recovery. We also will be hearing from the people who are leading the federal government's efforts to enforce the Civil Rights Act, as well as from key advocates who are working to make the promise of the law a reality. As we begin our program, I just wanted to take a moment. You're all special, and we're all delighted that you are here to join us today, and thank you for all the work that you do every day to make equality a reality. But I just want to recognize a few people who've had a particular history in enforcement of the law. First of all, my current colleagues, Commissioner Andrea Lucas and Commissioner Kalpana Kodagal, former EEOC commissioners Gilbert Casillas, Carrie Dominguez, Stuart Ishimaru, and Jenny Yang, Seema Nanda, the Solicitor of Labor, and numerous friends from the White House, thank you all for being here. And now, I'd like to introduce Monica Woods, who is the Chief of Staff here at the National Archives. Monica leads a diverse portfolio of activities here at the Archives. I think she was instrumental in getting us this lovely space for this celebration. Prior to joining the Archives, Monica held leadership positions at the Leadership Conference for Civil and Human Rights and the Urban Institute, as well as in the federal government. So it is with great pleasure that I turn the podium over to Monica Woods.
Thank you, Jocelyn. Good morning. And welcome to the McGowan Theater here at the National Archives. I'm pleased you could join us on this very momentous occasion to commemorate the 60th anniversary of the Civil Rights Act. The National Archives is honored to join our co-hosts, the U.S. Equal Employment Opportunity Commission and the U.S. Department's Office of Civil Rights to celebrate and reflect on pivotal legislation. 60 years ago, on July 2nd, 1964, President Lyndon B. Johnson signed the Civil Rights Act of 1964. This landmark law banning segregation in public places and discriminatory practices in employment became the most sweeping civil rights legislation since Reconstruction. Title VII of the Act created the Equal Employment Opportunity Commission with implementing the law. In the records of the National Archives, you can find the original Civil Rights Act, along with papers, photographs, and audio-video recordings documenting the hard work of the EEOC, the U.S. Department of Education, and many other agencies in implementing and enforcing the legislation in the wake of its passage. This morning, we'll be hearing from a distinguished group of speakers who will talk about the importance of the Act and the work that is still needed to fulfill its promise. After the program, I hope you have an opportunity to visit some of our exhibits, including our Records of Rights exhibition in the David M. Rubenstein Gallery, which explores the long struggle to ensure the promises of the Declaration of Independence, the Constitution, and the Bill of Rights are available to all Americans. Thank you for your presence this morning. It's great to see you, and I hope you enjoyed this morning's program.
So it is my great pleasure now to introduce a special surprise guest who wants to send a message by video. So please turn your attention to the screen to hear from Mr. John Legend.
Hello, everybody. I am so glad to be part of your commemoration today. Like you, I am grateful for the Civil Rights Act of 1964 and its protections against discrimination in employment, education, and so many other aspects of American life. Its enactment represents the best of America, and it reminds us of our commitment to the relentless pursuit of justice, equality, and inclusivity. Although some of the blatant forms of discrimination from 1964 still remain, we also know discrimination can look very different today. The country has made significant progress since the Civil Rights Act was enacted, but the law is as necessary today as ever. Today, I celebrate the Civil Rights Act and everyone, including the civil rights leaders and federal civil rights community who work to fulfill its promise. I want to express my deep gratitude to those who enforce civil rights laws and those who speak out and uphold people's civil rights, whatever your role. Happy 60th birthday, Civil Rights Act. I hope you all have a great event.
Okay, I'm just fangirling over here. But speaking of fangirling, it is an incredible pleasure to introduce the moderator for our next presentation. Michelle Martin is the host of National Public Radio's Morning Edition, which I suspect many of us in this room heard on our way into this event. She previously was the weekend host of All Things Considered and host of the Consider This podcast. Michelle currently serves as a contributor for PBS's Amanpour and Company, and her previous credits include ABC News and Nightline, as well as covering politics for the Washington Post and the Wall Street Journal. She has been honored by numerous organizations, including the Candace Award for Communications from the National Coalition of 100 Black Women. Michelle graduated cum laude from Radcliffe College at Harvard University and earned a Master of Arts from the Wesley Theological Seminary. In 2019, she was elected into the American Academy of Arts and Sciences for outstanding achievements in journalism. I'm delighted that we could be joined by such an illustrious moderator today who will be interviewing truly illustrious panelists. So let me introduce our first panel of speakers from the government. Catherine E. Lehman is the Assistant Secretary for Civil Rights at the U.S. Department of Education, where she serves as the Chief Civil Rights Enforcer in the nation's schools. Hello. If I'd known they were going to be walking out seriatim, I would have planned for walk-on music, but. Catherine has served as Deputy Assistant to the President for Racial Justice and Equity, chaired the U.S. Commission on Civil Rights, served in California Governor Gavin Newsom's administration as Legal Affairs Secretary, and was also Assistant Secretary for Civil Rights at the Department of Education during the Obama-Biden administration. Next, we have Kristen Clarke, who is the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. She was selected by President Biden in 2021 and confirmed by the Senate as the head of the Civil Rights Division. Before her nomination, she was the President and Executive Director of the Lawyers Committee for Civil Rights Under Law, where she led the organization's legal work addressing some of the nation's most complex legal issues and civil rights challenges. And finally, last but not least, Charlotte A. Burrows is the chair of the Equal Employment Opportunity Commission. Chair Burrows was first nominated by President Obama in 2014 and renominated by President Biden in 2023. Prior to her appointment to the EEOC, Chair Burrows served as Associate Deputy Attorney General at the U.S. Department of Justice and as General Counsel for Civil and Constitutional Rights to Senator Edward M. Kennedy. I am confident that you will agree that this is an extraordinarily distinguished panel, and I will be so excited to hear from them. Thank you all for being here today and for all you do to advance the cause of civil rights.
No pressure at all. So, thank you all so much for being here. Thank you so much for being here. Thank you so much for being here. There are a lot of places you could be. It's really hot out, so especially those of you who walked. But thank you all for coming to be part of this conversation. You know what, I just wanted to start with a little biography. I don't want to put you all on the spot, but I'm going to. All of you could be doing something else. I mean, you could all be doing something else. So I just wanted to just briefly ask why you chose this, why you chose public service, and why you chose this role. Catherine, Madam Chair, do you want to start?
Yes, and good morning, and thank you so much, Michelle, for your fantastic work, and that has been really inspirational. But I will say thank you to everyone else who's here as well. I grew up in the South, and to a father who was born in the Bahamas, but came to the U.S. as a teenager, and a mother whose family had been in the United States for many, 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 many generations. And so had the ability to see America both from that immigrant land of opportunity view, but also from the reality of folks who were not immigrated, but imported, if you will, and had been here working extremely hard, but also saw the American dream in a different light. One thing that I was really fortunate for, I grew up mostly in North Carolina, South Carolina, and of course the Richmond area. But we had, the parents' generation, and I'm so sorry that Dion Diamond, who was one of the freedom riders who helped establish the Civil Rights Act, was not able to join us. But that generation really worked so hard to create and instill, at least those I was around, in us this idea that you had to be giving back.
Yep.
You had to be working more. And these were people who, you couldn't tell it at the time, but who had gone to school being treated like criminals for trying to get an education, spat upon, etc. And yet they saw as their first job to cherish us. And I had the great good fortune of grandparents and great aunts who looked at us and they just saw hope and delight, and you could feel that.
Yeah.
And so that plus this, not that there was they were sort of a no-nonsense, no excuses bunch, but definitely you were cherished. And so what they were constantly saying is that you had to give back. And that was their own, that and the fact that I was a middle child constantly looking for, fairness.
Well, I will say this. We all miss Mr. Diamond, but because you are here, he is here. I will say that. Assistant Attorney General Clarke, what about you? Why this work? Why public service, and why this particular form of public service? Why civil rights?
Well, thank you. It is great to be here and great to be on this dais with these amazing women leaders. So I think, for me, it was about finding my purpose, and I feel very lucky. I kind of figured out, or had a sense, a good hunch about my purpose in high school. I'm the daughter of Jamaican immigrants, so first generation, grew up in the East New York section of Brooklyn. And I grew up understanding what it meant to struggle, what it meant to be Black, to be a new immigrant family, part of a new immigrant family in this country, struggling, trying to make $1 out of 15 cents. And had the fortune of leaving Brooklyn and going to a boarding school in Connecticut, where it was the exact opposite. I had a front row seat to what privilege looks like in this country. It was very unsettling to kind of move between these worlds as a young person, very startling. But in my junior year of high school, I also had the chance to sit in on a school desegregation case, dealing with the question of racial segregation in Hartford, Connecticut. And it was really eye-opening and amazing to see civil rights lawyers at work wrestling with these really hard questions that we face as a country. How do we, achieve racial integration? How do we close the gaps between the haves and the have-nots in our country? But that moment for me lit a spark that I followed throughout the rest of my journey. And I feel very fortunate to say that I've woken up every day as a lawyer committed to doing civil rights work and to standing up for those who are not privileged in our country.
What about you, Madam Assistant Secretary Catherine Lehman? Why this work for you?
Well, you started by saying that we could do something else, and I think we all know I really couldn't because I did this job twice. So, I mean, one reason is this is truly what I love. I spent 17 years suing government before coming to government, so it hadn't been my plan to be government. It was my plan to ask for government to do more, but I certainly had a lot of views about what I wanted government to do when I came. But I think also, the people who raised us, the people who made us, are the people who are here with us. And my parents were civil rights activists. They were freedom riders, and they sang freedom lullabies to me as the raising. So I really didn't have a choice. This is what I do. It's in my blood. So.
But there is an interesting question about do you stay on the outside or do you come on the inside?
Yeah.
That is an interesting question. So I was curious about that decision to go on the inside, and was it a struggle for, especially for both of you, because you were on the outside, suing government, and you were on the outside suing government. I was just curious, just briefly, because I do want to get to the current work of the agency, but I am interested because we see all these polls about how younger people really care about service, but they don't necessarily want to be in government. And I don't know whether, you know what I mean? And I'm just curious for you, what was that hinge moment for you when you said, okay,
Well, it wasn't
I'll
hard.
move
I got
from
a
that
phone
table
call.
to this table.
I got a phone call and said, do you want to come and work for President Obama? And the answer was yes. So, I mean, it wasn't hard.
Okay.
But it also is the case that I can do so much more from this chair than I ever could do
How come?
outside.
Why?
Because there's 49 million public school students whose access to education hinges on the decisions that we make as government. There's another 18 million college and university students whose access to education hinges on the decisions we make. And so either we use the levers that we have effectively for every student who needs us every day, or we don't. And when I was outside, I could spend 5 years working on, one of my cases affected 1 million students. It was incredibly impactful. I was so proud of it. It doesn't even, approximate what we do every day when we have access to justice for that many people. So.
What about you, Assistant Attorney General? I mean, was there a hinge moment for you? Like, do I stay on the outside? Do I move to the inside?
I engaged in protest as a college student and law school student. I worked for the Lawyers Committee and Legal Defense Fund, so I understand the power of grassroots lawyering. But there is something unique about doing this work on behalf of the United States. You have federal civil rights laws and all the awesome powers that comes with, and the ability to make sure that we are using those laws to confront the most gravest, the grave injustices that we face in our country. So I appreciate being able to do this work from this seat.
I just want to say, for those of you who are in public service, it is common that we often thank our public servants in uniform, but we don't often thank our public servants who are not necessarily identifying themselves as such. So can we just take a moment to thank all of you who are in public service. Because it is a sacrifice. You are held to a very high level of scrutiny, and it is not easy. It can be, I think, emotionally draining in ways that perhaps people don't fully understand. There is no place to hide, and so I just want to say, for those of you who are engaged in this work, we see you. We see you. We see you. Having that being said, the Civil Rights Act was pivotal to the creation of all of your agencies, which is assuming why you were invited here. So, so I just wanted to sort of ask if we could sort of fast forward a bit and ask each of you, what do you see as the most, obviously policies are set at many levels when you're in the federal government. I mean, there's what the White House wants, and then there's the institutional sort of imperatives. But I would like to ask each of you to sort of name sort of the top 3 things that you think your agency is currently engaged in that is most pressing and relevant. And if I could ask you, Madam Chair, to start.
Sure. We have many enormously important issues. Right now, one of the things that we are doing that I think is really critical is working very hard on anti-harassment provisions. Believe it or not, harassment continues to be one of the most egregious workplace issues that we have in the United States on all bases. We had a wake-up moment for the United States around Me Too going viral, which was really important to put front and center the issues of sexual harassment. But the reality is, on every basis that that our laws cover, from national origin, race, religion. We've even had a genetic information non-discrimination act harassment case. We've had disability, age, over and over. Those continue to be problems.
And why is that? Is it because people don't know, or because people are terrible? I don't know what is it like. Do they not know what the law is, or why do you think?
So you raise a really good point, and I'm going to be succinct here because we don't have but so much time. But this is one of those issues that people know basically in kindergarten that you're not supposed to be doing this, right? So it is not a question of mistake of law. It is typically culture. And it was also kind of a second generation problem. So the act insisted that you knock down the doors that you started, not that people don't still discriminate in hiring. But for those who were not ready for that, their response was harassment. And you see in certain industries that culture allows, unfortunately that's perpetuated. So it's unusual, but I actually last year did a report on the harassment in the construction industry. It was about more than harassment, but that industry is one that we're looking at very closely and making great strides, and the vice chair has really been leading in this too. But there are pockets of, it's a cultural thing. It's what's allowed, how you can treat each other, those things, there's a norm. There's some people who are always gonna do the wrong thing. But most people are gonna look around and see how are we behaving here? How do we show up? And if you have a culture where that's a problem, you quickly will end up with people feeling comfortable.
Interesting. I'm going to ask the others to answer that question, but then the other thing I'm going to ask afterwards, a follow-up, are there things that you're working on that people would not expect that they don't necessarily understand as being part of your portfolio? But before we do that, Assistant Attorney General, what are one of the top 2 priorities that you're working on?
Yeah, so I'll flag one issue that I think is gripping our country right now, sadly, hate crimes.
Yep.
Hate crimes, hate incidents, sadly we see, white supremacist violence, anti-Semitic, Islamophobic, all forms of hate that we have an obligation to stand up to. How does that connect to the Civil Rights Act? Well, I'd like to view some of the work that we're doing through Title II as one of the tools in our arsenal here. We went after a hotel in South Dakota not long ago that put up a policy that said no Indians allowed, essentially. This is still happening in 2024. And when we think about the heyday of the Civil Rights Movement, the folks who are engaged in sit-ins at the lunch counters, the folks getting on the buses. I mean, Title II is, one of the core provisions of the act that most people think is collected dust and is something we just don't need anymore, right?
Well, we're all not lawyers, so what is Title II?
Title II of the Civil Rights Act essentially desegregated our lunch counters and motels and restaurants, and basically said that our public accommodations, these public establishments can no longer say whites only.
Did they actually have a sign saying that no Native Americans or no Indian? I mean,
It was a written policy. And they had
Wow.
Perks for white people. And in 2024, these are some of the battles that we're still fighting. So that, to me, I view as part of the work that we're doing to confront hate. Yeah, we're going after the defendant who carried out the massacres at the Tree of Life Synagogue, the Walmart in El Paso, Texas, the Top Supermarket in Buffalo, New York, all of those horrific tragedies. But we're also dealing with this other, ugly form of hate that we can't ignore in our country. Another big issue for us is constitutional policing. Heeding the call of the people who were engaged in protests in the wake of the tragic death of George Floyd, the call for constitutional policing. We are investigating police departments engaged in systemic misconduct. We are holding officers accountable who take lives, including officers responsible for the deaths of George Floyd, Breonna Taylor, Tyree Nichols. But we also have Title VI of the Civil Rights Act of 1964, and that provision says that any entity that receives federal funds in our country can't discriminate. Sounds sleepy, but it actually is the heart, another core provision of the act that gives us the ability to go after police departments that receive federal money and other entities like courts and prosecutors' offices that engage in discrimination. And so that's another tool that we're using to help promote the goal of constitutional policing in our country.
Assistant Secretary Lehman, what are 1 or 2 top priorities for your department at the moment?
The thing I think I'm proudest of that we're doing is that we're fulfilling the ambition of the act, which is President Kennedy, when he was advocating for its passage, said it was to achieve the simple justice that no federal funds would be spent to discriminate on the basis of race, national origin, and color. And that is such a beautiful promise and turns out quite hard to achieve over time. And the statute, the text itself, promises that no person shall experience discrimination. So the recognition that the law is for everyone and that the law applies and protects everyone is a challenge every year. Every school year is a new opportunity to discriminate. And we have, this year, entered into resolution agreements to resolve shocking discrimination of the type that is very similar to what you described. We just resolved a case also in South Dakota where the superintendent of a school district that is 28% Native American reported to us that the reason that there was so much higher truancy rates for Native students than for white students is that they operate on Indian time, which I find shocking that she would say that to us in an interview, and that, you know, recognize that that would be part of the evidence that we take in, that was her explanation for why she treated her children differently in her district. And she doesn't anymore. We now have a commitment that they will actually not discriminate on the basis of race and national origin against these students, but 2024 that we had to secure that commitment from the superintendent of that district. We also just investigated a case where there's 6 Asian students in the school that I'm going to describe, and a white teacher posted an image of Kim Jong-un on the board and compared the one Asian student in his class to Kim Jong-un and invited the students in the class to laugh at him and to talk about whether that's who he is. And, you know, of course, we recognize that as creating a hostile environment for the student. The good news is that the principal in the school immediately stepped in, did the right things for that student, ensured that that student didn't experience discrimination moving forward. But again, this is what a middle school child was required to experience. He's required to be in school, was required to experience now. And it required federal redress to make sure that his rights were fully protected. So I am proud that we are there for each child who needs us every day in every school.
Are there things that, we'll go back the other way too, are there things that you're working on that maybe people broadly defined might not see as discriminatory, and that there's a level of education discussion that takes place because people don't necessarily see it as having a discriminatory effect? I mean, there are just a lot of things that come. I'm just thinking about the fact that this summer we will observe the 10th anniversary of the unrest in Ferguson, Missouri,
Yes.
when Michael Brown was killed after this incident at the gas station. And the reason I raised that is that it emerged that one of the sources of frustration for the community is that, you know, fines and fees
Right.
were very much a part of the budget, and it wasn't really so much a law enforcement, you know, it emerged that the community understanding for the people who were subjected to this, and I'm sure that other people disagree, was that fines and fees were not really related to law enforcement. They were really related to, you know, filling the budget.
Right.
And that was part of the source of the frustration. So people didn't really see it, like all the tickets for keeping your grass too high or tickets for having a taillight. And I will tell you that I was there 3 weeks after to conduct a community conversation, and I saw, within the span of an hour being on the ground, I saw this
Yes.
in front of my face,
Yes.
where a boy was going to cut a woman's grass, and he was pulled over and given a ticket, and the woman whose grass he was going to cut came out yelling, "This happens all the time. He's going to cut my grass." And apparently he got a ticket for, apparently they didn't like where he had his lawnmower. So, I mean, anyway, all I'm saying is, are there things that people wouldn't necessarily see that are part of your portfolio?
I first want to call it what it is, right? Because what you just described, the people who are subject to it do see it. They do know, right?
Yeah.
And we do know in our communities what discrimination looks like. We know every year, and what we don't always get is the federal government there for us. What we don't always get is the recognition that the injustice that we live, that we know, is wrong. And to have the federal government stand for us is the simple justice that President Kennedy promised to us, is the charge of every public servant who is here to do this work. And I think that is crucial. I agree with Chair Burrows that it's not as if we don't know what discrimination looks like. It's not as if we don't know what we're not supposed to do. But we think we might get away with it, and we too often do. So what we need is to be clear that it's wrong. I find myself stunned in this role. Now, stunned in this role when I came into it 11 years ago by the number of people, often lawyers, who are charged to do the right thing in their schools, who say to me, well, that's new to us. We didn't know. This law is 60 years old. You know, it is not new. And the civil rights laws that have passed it are not that much younger than it is. These are not surprises to us. And so the kinds of discrimination that we see happens because people think they can, and they need to be told they can't.
Assistant Attorney General, is there something that is part of your portfolio that people might not necessarily see?
So,
Not disagreeing with anything you said, but
Yeah.
just
Right,
saying
yeah,
for the sake
yeah.
of discussion.
Yeah.
yeah, environmental justice comes to mind here. I feel that in our country today, communities of color, tribal communities, poor communities bear the brunt of a lot of injustice. Pollution, lack of access to clean water, high lead exposures to high lead levels, and it's sometimes hard to figure out the why. And it's one area where I've been very proud of some of the work we've been able to do since 2021 through use of the Civil Rights Act of 1964, that Title VI provision that I talked about. We went out to Lowndes County, Alabama, poor rural community in the Black Belt of Alabama, just south of Selma. And this is a community for generations where people have been without access to adequate wastewater removal systems. We kind of all take it for granted. When we use the restroom, we flush, and we've got sewage systems that take care of that. These folks have been left to create crude pipe systems to try and remove waste from their homes that, because of climate change, is not absorbed into the soil. It rushes back onto homes and backyards and playgrounds, and the health consequences that have resulted have been horrific. And so we've been able to do some work here going after Lowndes County, Alabama, that receives federal money for failing Black people, for failing to simply provide them the access to wastewater removal systems that they need to live, to breathe, to thrive. Illegal dumping in Houston, Texas, it's another example of work that we've been able to do using the Civil Rights Act. So that's one area that comes to mind.
Chair Barnes, what about you? Are there things that come before you that perhaps people might not expect?
Well, one issue that's really important to me, and we're doing a lot of work in this area, is looking at how artificial intelligence is affecting the way that people get jobs and keep them and how they're treated while they're there. So things like algorithms that determine whether or not your resume looks like the resumes of those who were previously hired. And some of you may be familiar with the example of a resume screener that decided if you're, played lacrosse and your name was Jarrett, you were probably qualified for this engineering job. Obviously, that is not usually the way one would want to hire. So some of these programs probably have promise, but we really have to understand that we have to be nimble enough now to bring those 1964 principles into the high-tech world that we are living in with respect to employment today, and that's something we're working very hard on at our agency at the EEOC, but also with the Civil Rights Division and education and some of our other partners under the executive order that President Biden put out. I would say just very quickly, two others that I think are really important that people may not be thinking about is we are also looking at diversity, equity, inclusion, accessibility, because although we enforce the Civil Rights Act and other anti-discrimination laws, what those laws are is a backstop. So if the discrimination happens, you can get a remedy, but it's really important to try and get in front of it. And so there was always, initially and now, the need and the expectation that there would be room under the law for people of goodwill to lean forward and bring our highest values closer, our practices closer to those values of equality. And a lot of employers have begun looking at how to do that, how to have more inclusive employment practices. And that's something where we have expertise with respect to, okay, here's how you can do it consistent with our anti-discrimination laws. And that's enormously important that we, expand opportunities for everyone as opposed to just waiting and fixing a problem after the discrimination has happened. Super important. We're very proud of that work. But if we're going to get to full equality, to really see the vision, we've got to make sure that we are also leaning in and being inclusive proactively. I think the third thing is that, although it's not under the Civil Rights Act, it's the Pregnant Workers Fairness Act, which is a law that basically says you have got to accommodate If there's a limitation due to pregnancy, childbirth, or related medical conditions, that should not be the end of your career or you have to get out of the workplace if you need something simple to do your job. We actually have in the legislative record is full of it, women who just needed to sit down and have a break or drink water or stand up just to get a little rest or maybe take a food break when they were pregnant, who were denied those kinds of things. And so the law was really there and has already been working to help allow people who just needed some sort of accommodation, who were pregnant workers, to stay in the workplace at that time when it was so important just to keep having your income. And they could do the job, but they needed some flexibility. And so we were able to reach that to some degree under the Civil Rights Act and the anti-discrimination, under the sex discrimination part of the act, but not all of it. And so that has been enormously important as well, and we're very actively working on that, as well as just issued a new regulation.
Do you all have tools short of litigation? I mean, law is a blunt instrument. By the time you get to litigation, it's it's painful for everybody. I mean, maybe not for you because that's like where you are every day. But I was thinking about. I could tell a story all day long, but I was thinking about the time when my kids were little and I had to get those tubes. Those kids when they were having a lot of ear infections, and they get those tubes to get the thing, and I'm in there. I'm like, oh, my baby. And then there's a friend of mine who's a doctor, and he's like come in and he's telling jokes, and I was like, why am I so upset and you're not? He goes, because this is where he said, because this is my home base, and if I were to come to your studio, I'd probably be crying too. So I guess what I'm saying is maybe it's not a big deal to you, but but for a lot of people it's very traumatic. And I guess I'm just wondering if, I'm just going to disagree with you a bit about what everybody knows, because I'm not sure everybody does know. I mean, we consider how siloed we are. Our information is so siloed in this country. I'm never convinced that everybody knows everything. I mean, just to get it out there.
I think they don't know what we know with the expertise that we know it.
Right.
But
All I'm saying
they know
is,
the simple justice.
are there paths to justice that don't involve the hammer? Do you have tools short of meet you downtown?
Well, we don't have to meet you downtown. We'll meet you at my office. But we do administrative enforcement.
Okay.
So it's speedier for us, which I love. And our ultimate tool is withholding federal funds, which we mostly don't have to do, because when you say, I'll take your money, mostly people say, okay, I'll stop discriminating, which is good.
Fair. What about you? Do you have tools short of the hammer?
So I believe deeply in getting outside of DC to do this work and spend a lot of time traveling across the country, hearing from communities, listening to the problems they're experiencing, but also, on the flip side, lifting up the enforcement work we're doing, making sure that every matter sends a strong message and has the ripple effect that you want to have across police departments, across industries, across different sectors. So Rankin County, Mississippi, we prosecuted several officers there who tortured 2 black men, horrific.
You're not joking. I'm familiar with that story.
Yeah, 40-year sentence.
It's a very disturbing case for those of you who are interested.
Yeah.
Well, we should all be interested, but I'm just saying that you're not exaggerating when you say tortured. I mean, and lied about it, obviously.
Yeah. And the lead defendant got a 40-year sentence, just about the largest sentence ever.
Okay, but the plane has already crashed in that case. This is what I'm saying. The plane's already crashed in that case, right? And
but
so
hopefully
it
has the ripple effect, right? Hopefully it's sending a message to law enforcement officers across the country that you will be held accountable, because we can't sue everybody. So that's how I was answering your question, that everything that we do, we want and hope will have a strong ripple effect that gets gets bad actors to conform their conduct to the law.
Well, let me pick up there, because the EEOC really, really believes in using all these other tools in the toolbox in addition to litigation. That is, we're a small agency. We are perpetually under-resourced, and we are also really aware that the biggest bang for the buck, as the AAG was saying, is really not with the people that you sue, but with the people, mostly of goodwill, who will do the right thing if you explain to them clearly, here's what that looks like. We do a lot of work doing outreach, explaining that there was a lawsuit when we get a lawsuit that's out there. So that's very important. But also education and technical assistance. So, you know, just as examples, earlier I was talking about artificial intelligence and well, what does that look like? So we spent a lot of time producing documents that said, okay, here's the Americans with Disabilities Act, and here's what we're seeing. Let me map that out for you as to how there could be a violation and tell you here's some promising practices so you can avoid that. Make sure you can have an accommodation if someone's asking. The same thing with the Civil Rights Act. Here's what you might run up against if you use these tools and you're not checking, right? So we firmly believe in that, and also getting out to tell people what their rights are. A lot of people do not believe, and that was something that the sort of leaders that got us the act through the March on Washington, through all of the quiet, smaller marches and demonstrations. We just had one of the folks in the Rock Hill 9, which is where my grandfather had one of his churches down in South Carolina, just passed. And so sitting in at those lunch counters that the Assistant Attorney General was talking about in the 60s, we get that baton, and the way we pass it is people cannot march it every single day. They cannot sit in every single day. What the implementation of that looks like is really nudging things in the right direction. And so that if government is working right, and if people of goodwill are leaning in, doing the right thing, you don't have to march every day. You can actually get what the ask was at the 1963 Civil Rights, so March on Washington for Jobs and Freedom, which created our agency, which created the Office of Civil Rights and Education. You can get a better, more just system so you don't have to be in the streets every day. And that implementation, I think, back to your original question of, you talked about young people thinking, well, inside that doesn't look like what I think the change is. It's part of it. It's definitely not the whole thing. But that's the key, is to have this baked into our system, which is why I think government is important. But we do a lot to educate, because I do believe, we've been a little bit pessimistic here, but I do believe that most people are people of goodwill who understand how important civil rights is to this country.
I take your point, but we're not going to resolve this here in the time that we have. But what constitutes, what is the highest expression of our values is a matter of disagreement. Because if it weren't, then we wouldn't need you all to resolve that, right? There are some people who have very different interpretations of what justice looks like, what fairness looks like, and it speaks to some of the deepest emotional, religious, beliefs that people carry within them. And so, because if it was obvious, we wouldn't need you all to resolve disputes about it, right?
I don't mean it's unanimous, and I didn't mean to cut you off, but I feel so strong. It's not unanimous, and that diversity of views is how we learn from each other and understand, but most people, and I say that with a lot of confidence, understand that we have to treat each other, whether you're religious and see that as the golden rule or something else, that we have to treat each other the way we would want to be treated. And so I say that with, each of the statutes, pretty much all of them that we enforce, beginning with the Civil Rights Act, huge controversy, longest filibuster in U.S. Senate history still, and yet, I think it was June 10th, the filibuster was broken and we got the statute. So it's not that there's not controversy and disagreement, but at the end of the day, what rules is that we really do believe in equality and justice for all. That's what I think. And if you look at the votes on every one of our statutes, broad bipartisan majorities from 64 right up into 2022 with the Pregnant Workers Fairness Act in both chambers of Congress and signed into law. And so I say that not naively, I am very well aware, there were a lot of things, and, we had literally in the Carolinas where I grew up, there were people who were saying, for religious reasons, that people should not be, of different races should not be sitting at the same lunch counter. And yet we got here.
So that's a great place to end. I'm going to ask each of you if you would give us we're almost out of time, but just give us each a closing thought. You've kind of given us a great sort of charge to leave here with, but can I ask each of you, would you just give us a brief closing thought? What would you like us to be thinking about as we conclude our time here?
Well, I hope that we're celebrating 6 decades of this enormously beautiful law. I hope that we can expect 6 and 6 and 6 more decades where this is our shared expectation, where this is our bipartisan consensus about what our rights are, who we will be, and how serious we are about living them. That has been important for as long as I've been alive, and it is always fragile. It is always worth working to protect that set of rights and what they mean for all of us. So I hope what we're doing today is redoubling our commitment to the decades that will come too.
Yeah, and I would say that the Civil Rights Act embodies the spirit of so much, the spirit of activism, those who marched. It embodies the spirit of young people who sacrificed and led. It embodies the spirit of the courts and civil rights lawyers who fought. The spirit of lawmakers who in bipartisan fashion came together and worked together. And we made a lot of progress, but we still got a lot of work to do. But I think this law provides a roadmap for how we can continue to advance the cause of justice and equality going forward. It's everybody. It's courts, it's government, it's students, it's activists, it's all of us.
Madam Chair, a brief final thought from you?
I would just agree with the other panelists and also say that the enormous progress that we have seen, we also know that we are not done with the project of including absolutely everyone in the broad American dream of equality for all, and that it is fragile. And so we have to remember both to keep reaching for that additional progress, but also that we can't take for granted what we've gotten. So I thank all of you who are committed to that along with us, and it's been an absolute pleasure.
Charlotte Burrows, Kristen Clarke, Catherine Lehman, thank you all so much for being here today. Thank you. And we're going to turn it over to Matt Nosenchuk, please stay around because we have another panel for you, a panel of advocates, and Matt Nosenchuk is going to bring them out after we take our leave.
Thank you so much. Good morning, everyone. My name is Matt Nosenchuk, and I'm a Deputy Assistant Secretary for Strategic Operations and Outreach at the U.S. Department of Education's Office for Civil Rights. It's great to see so many of you here today, many colleagues and friends from the agencies that co-sponsored this, EEOC and Department of Education, as well as the Department of Justice. And I just want to give another round of applause to Michelle Martin, and the extraordinary panel that we just had with Assistant Secretary Lehman, Assistant Attorney General Kristen Clarke, and Commissioner Charlotte Burrows. And it's just been a true honor to have the opportunity to work with Assistant Secretary Lehman, and I previously worked in the Civil Rights Division at DOJ, worked with Commissioner Burrows when she was at the Department of Justice. So we now are going to transition from a panel where we heard from leaders inside government to a panel of individuals who are leaders outside of government. And as someone who has worked both inside and outside of government to fulfill the promise of the Civil Rights Act of 1964, as you heard, I mean, those are indispensable components of the project of achieving greater equality and justice in our nation. The outside advocates engage with, cajole, pressure, those who are working on the inside, and those on the inside do what they can to move the levers of power to move government work towards fulfilling greater justice and equality. At least that's the aspiration, and that's certainly what our panelists here did, and we'll now hear from those advocates who are doing that work on the outside. We have I want to first bring out our moderator, Carla Gilbride, who is the General Counsel of the Equal Employment Opportunity Commission. Carla was confirmed by the U.S. Senate on October 7th, 2023, to a 4-year term. She has deep experience litigating cases on behalf of workers and consumers. Before joining the EEOC, She was co-director of the Access to Justice Project at Public Justice, a nonprofit organization. Shout out to Public Justice. Oh, and to their new leader, Sharon McGowan. Good to see you. Former DOJ colleague. I also want to introduce Damon Hewitt, who is the president and executive director of the Lawyers Committee for Civil Rights under law. Damon has more than 20 years of civil rights litigation and policy experience, including prior leadership roles in nonprofit, philanthropic, and public sectors. Prior to joining the Lawyers Committee, Damon was the inaugural executive director of the Executives Alliance for Boys and Men of Color, as well as the chief liaison from the philanthropic community to the White House on policy issues impacting young men of color. He worked for more than a decade as an attorney at the NAACP Legal Defense and Educational Fund, where he was lead counsel on a variety of litigation and policy matters and supervised teams of lawyers and policy experts. And he is leading an organization that is working to bring the spirit of the Civil Rights Act of 1964 into the modern age to address all of the issues that face us today. And I was reading about his recent appearance on the Hill in relation to AI and civil rights. Next, I'd like to bring on Monica Ramirez. Monica is a lifelong advocate. She began writing stories about farm workers and Latinx communities when she was just 14 years old. She's an attorney now, an author, and an activist fighting for the rights of farm workers, migrant women workers, and the Latinx community. She founded Justice for Migrant Women and co-founded Alianza Nacional de Campanistas, the Latinx House, and the Poderistas. She has received numerous awards, too many to name here, and we are just thrilled to have you here today. Thank you, Monica, for coming. Next, I'd like to bring on Janae Nelson. Janae is president and director counsel of the Legal Defense Fund, the nation's premier civil rights law organization fighting for racial justice. Before becoming the president and director counsel, she served as LDF's associate director counsel. She's an expert in voting rights and education. When she was appointed, she said in a Washington Post interview that the next generation of activists and young people need to see that the fights they are most concerned about, their ability to have opportunities, employment, access to education, and to live in a world that is not threatened by destruction because of climate justice, that these types of battles are civil rights battles. Finally, I'd like to bring out John Yang. John is the president and executive director of Asian Americans Advancing Justice, AAAGC, in Washington, D.C., where he leads the organization's mission to advance the civil and human rights of Asian Americans and to build and promote a fair and equitable society for all through policy, advocacy, education, litigation. He served in leadership positions at the ABA, the Asian Pacific American Bar Association, the National Council of Asian Pacific Americans, among many others. He also was a fellow appointee in the Obama administration, working at the Department of Commerce, and has served in a number of other roles. I am thrilled now to turn the panel over to Carla for what will be an amazing discussion. Thank you.
Thank you so much, and I'm thrilled to be here with all of you to reflect upon the impact that the Civil Rights Act has had in the 60 years since its enactment, and to commit ourselves to the work still to be done. And after hearing from the thoughtful and inspiring remarks of my colleagues on the previous government panel, I'm particularly honored to be sharing the stage with all four of you dedicated advocates who have spent your careers bringing the ideals of the Civil Rights Act closer to reality and continuing to advocate for change. On a personal level, as someone who's spent most of my own career outside of government, advocating both inside and outside the courtroom, I feel a deep kinship with each of you, as well as a deep inspiration and admiration for your thoughtfulness, your strategic approaches to these issues, and your persistence in striving for justice and equity. So I'd like to sort of kick us off by turning to each of you in turn, starting with you, Damon, and to ask, from your perspective as an advocate, what do you see as some of the greatest improvements that the Civil Rights Act has made possible, and where are areas where you feel its promise is yet to be fulfilled?
Well, thank you so much, Carla, and to all the leadership at the EEOC and Department of Education Office of Civil Rights for convening this program and for having us. The question you've asked, we could spend the entire day. And so I'll give you a couple of snippets. It's difficult for me to start without thinking about education, public education. You know, the Supreme Court told us in Brown v. Board that education is the very foundation of good citizenship, right? Yet, it took 9 years after Brown won, several years after Brown won, and Brown 2, to actually get legislation, like the Civil Rights Act, that would actually help to really enforce and move that mandate and move this nation beyond massive resistance, which we saw in states like Virginia and so many other places. You know, for me, it's very personal. I grew up in New Orleans, Louisiana. It is the home of Plessy v. Ferguson and so many famous cases. It's the home of Ruby Bridges, but also of Gail Etienne and Tessie Prevost and Leona Tate, who desegregated New Orleans public schools, all on the same day, but without quite as much fanfare. That desegregation was in 1960, I think, or 61, their efforts. But after Brown, New Orleans decided we're going to create a special school for the most elite, a math and science high school. It's the kind of school that would help the United States become competitive in the space race. This was around the Sputnik era, right? And so this school called Benjamin Franklin Senior High School was created in 1957 after Brown v. Board. But you didn't see any black students there. Even after the New Orleans 4 desegregated elementary schools, you didn't see any black students there. It took the Civil Rights Act in years and decades, frankly, of enforcement. And that school's important to me because it's the high school I attended. It's also the high school that brought us Wynton Marsalis and Wendell Pierce, people in the entertainment industry from New Orleans, right? And so the very pathways to opportunity that I and so many of us in this room have enjoyed are not just because of Brown, which is seminal and foundational, but also because of the effort to push past the political and the personal resistance, not just to desegregation as a mandate, but to opportunity. If there's anything that I would say is left untouched, and we'll talk more about it later, it's frankly the speed of the mandate. It's the strength of the mandate. I think that government needs more tools and private actors need more tools. I wish we had clear private right of action to bring disparate impact claims. So my entire legal career since 2000, essentially, since the Supreme Court decided Alexander v. Sandoval in 2001, we've been deprived of the ability to call the thing what it is. Whether you have a smoking gun of intentional discrimination or not, there's still structural racism and structural discrimination in play.
Sure.
And so we need a stronger act, and there can be a legislative fix for that. That is within our reach and in our grasp, or at least it should be. If we get a Civil Rights Act passed in 1964, think about what this country was then. Why can't we get something new today?
Thank you. Turning to you, Monica, what do you see as some of the greatest achievements and also promises unfulfilled?
Thank you. It's really an honor to be here with all of you today. I mean, I think first and foremost, the Civil Rights Act did something that was so fundamentally important, which is that it recognized the humanity of all working people across our nation. Who we are as people deserves to be recognized, honored, and people deserve to be treated with dignity. And that is what the Civil Rights Act gave us, this incredible tool to ensure that we had something that we were working toward and something that we were working to hold employers accountable against the letter of the law. And so I just want to name that because I think that is so simple, but it is also incredibly fundamental. I think that in terms of specifics, and I come from the migrant farm worker community. Many of you in this room I've had the honor to know and work with over the years. And whenever I speak about this work, I speak of it from the heart and the place of the community that I come from and the community that I serve. And for my community, the Civil Rights Act has been so important because, first of all, if it had not been for the struggle of Black leaders who were fighting for the rights, basic rights, many of the Latinx leaders, many of those who are now Mexican American farm workers wouldn't have the tools to be able to fight for the same rights. And I want to make sure that we name that because it's important. What we have seen over time is that in sectors and industries, the makeup of the workforce has changed, like in agriculture. And if it had not come from the first fights, we wouldn't be able to build on the work that's been done over time to win justice for those community members. And today across the country, we're now seeing the workforce, the agricultural workforce, changing quite a bit as well. So now we're seeing more guest workers who are coming in from different countries. And there's a lot to be learned from the experience of agricultural workers over time of all backgrounds. But I think that some of the greatest gains in particular, and I agree that we could talk about it all day, I think some of the greatest gains with respect to the work that I've had the privilege to do alongside many folks in this room is, one, we have been able to tackle the pervasive problem of sexual harassment against farm worker women and against all working people. The work of the EEOC to address sexual harassment really that was placed at the forefront through the Strategic Enforcement Plan under the leadership and guidance of Cherry Shumaro when he was in his role, and said that the law was going to be implemented in a way that people who were the hardest to reach and the most at risk would potentially have access to justice under the law. And among those were farm worker women. And they were experiencing and continue to experience widespread sexual violence in the workplace. And so I feel like because that determination was made and because that was made possible through the law, we've now been able to see more people, migrant women, come forward with those claims through incredibly important cases like the Harris Farms case, which our friend Bill Tamayo helped to lead. But that helped to also give other immigrant and migrant women working across other industries more information about the possibilities for getting help and justice for the harms against them. So if you look at the development as things have progressed over time, we see not only farm worker women coming forward, but we see janitors, we see more restaurant workers, we see other people, particularly immigrant and migrant women working in lower paid jobs who have been able to see the examples of other women who've been able to bring forward their claims and win justice, and they've been the examples for them to then come forward as well. The other example of progress I would name would certainly be on the issue of equal pay, and in particular, thanks to the leadership of Lilly Ledbetter and the Lilly Ledbetter Act. As someone who's worked on equal pay, particularly focusing on the experiences of Latina workers, what's happened is that, first of all, we know that the pay gap has closed in part because of Lilly Ledbetter, her example, her leadership, and then the Lilly Ledbetter Fair Pay Act. We know that that's been possible because people understand now that those claims can be brought. We also have a different understanding under the law that it isn't, the law made possible for discrimination to be based on every single act, each paycheck, not just the first instance when the decision was made. That's important when you're talking about low-paid women workers, like the migrant women who I serve, who don't know when the decision was made or how the decision was made, but with each instance now have the opportunity to bring a claim. But as a result of that, we've been able to see the pay gap close. And I think as for those of us who are working on this issue every day, it's also allowed us to have a greater analysis as to how we're looking at the data and how the data needs to be pulled apart, disaggregated, so that we can have a deeper understanding of what individual women's experiences are so that we can better focus our energies to address that issue. There's lots of room for improvement. There's a long way to go still. And I would say that one of the challenges that we face as a nation, not only in the workplace, but I think as a country, and I would say even globally, is we have this increased situation of polarization. And polarization is pulling people apart, and it is making it more possible for discriminatory acts to happen, and it's playing out in lots of different ways and causing a lot of harm. in the meantime. And so I think we have to continue to do the work to, first of all, understand that we have a changing global context. And when it comes to working people, we are living in a global economy. And so the rules and the laws and the procedures that we have in place, including the administrative and investigative procedures, have to account for the changing dynamics of the workforce, including the new immigrant populations that are arriving to the U.S., some of whom are coming on these work visa programs. And then, of course, the other big challenge I think that we still have yet to address is the fact that there is a threshold that is in place, which is the 15 worker or more threshold under Title VII, and that's a big problem. I speak about it often. It's a big problem that we have people who are experiencing the same kind of violence and harm in a workplace that has 15 workers or more, and they have the possibility of justice under our federal law. And we have people who are experiencing the very same things in places with 14 workers or fewer, and they don't have access to justice. And that is wrong. And that is one of the biggest challenges that I think that we have to take up when we're looking at the possibility of actually curing some of the civil rights abuses that we're seeing across the country.
Thanks, Monica. Lots to unpack in there. I want to hear from Janae on, again, both the successes to date and some of the unmet promises.
Thank you, Carla, and thank you for that very touching introduction to bring us all into, I think, a centering around this important law. We are in an era of milestones around many civil rights laws and legislation and accomplishments that I think is a wonderful invitation for us to do exactly what you asked, which is assess how far we've come and what needs to be done. And it's easy to focus on how much is undone. There's so much that is left to be mined from these important pieces of legislation. And I think it's important for us to remember what it has provided so that we have an understanding of the foundation on which we can build. So when I think back to what was achieved in 1964, many people have already spoken about what an extraordinary feat it was to get this Civil Rights Act passed. It's not the first Civil Rights Act in this country. We know that the first one was in the 18th century, right? And we have come such a long way in having one that was cemented and solidified, and one that we could enforce in courts and put flesh on the bones of the words of the Civil Rights Act of 1964. So when we assess it, it's not simply the act itself, it's what activists, what the government and others have done to imbue life and meaning into the words of that statute. And so I think back to one of my predecessors, Jack Greenberg, who was instrumental in developing the doctrine of Title VII and did the work in Griggs versus Duke Power that endures today, that gives us the framework for discrimination in the workplace, whereby if there's a practice or policy that actually wreaks havoc on a particular group and has a disproportionate impact and harmful impact in terms of their prospects for employment or their abilities to succeed within employment, and if it's not a business necessity or it can be achieved through lesser means, then we know there's an obligation, there's a mandate now that wasn't as clear in the text of the statute, but by virtue of the litigation that fleshed out the doctrine, we now know that we have that framework for disparate impact that endures today and informs areas of law beyond employment. So that's the power of the Civil Rights Act and the power of what was done in the 60s and 70s that we can now build on today. From that decision came many, many others that allow us to look into practices that have a discriminatory impact on workers, not just based on race, but based on so many different characteristics and categorizations. And that is the power of that broad understanding of the Civil Rights Act that was achieved through litigation and through the activism of individuals who are willing to put themselves on the line. I think about a white woman that the Legal Defense Fund represented early on in the enforcement of Title VII, which was Ida Phillips. Many people don't know about a case that we led, Phillips versus Martin Marietta Corp., which was a case on behalf of a white woman who had young children at home and was told when she went to seek employment at a factory that she really shouldn't be working. She should be staying home taking care of her kids. That wasn't that really the role that she should occupy. And that case opened up the waterfront for many women at home with children who needed to work in order to sustain their households. And if you think about that decision and you fast forward to the Lilly Ledbetter Act and other ways in which we now see pay equity and equal access for women and other working people, we see the foundations from that era. So I want to underscore that because I think it's important for us to recognize what is unfinished business, but also recognize what we were able to do at that time and the expansiveness of the Civil Rights Act of 1964 and what we have to build on. There are many frailties and omissions that exist. We are, in addition to celebrating the 60th anniversary of the Civil Rights Act of 1964, we're celebrating the 70th anniversary of Brown versus Board of Education. That is a case that, as we all know, transformed this country irreversibly. I will say that, irreversibly. As much as we know extremists are trying to take us backwards, that decision transformed this country in every possible way and made the Civil Rights Act of 1964 possible. And we still know, however, that even though Brown, its mandate was to desegregate schools, segregation, intra-school segregation and inter-school segregation still pervades. We know that 75% of children in our K through 12 schools attend schools where they're in the same race or ethnicity. That's the predominant population within their schools. We also know that Black and Latinx schools and some Asian American schools as well are deeply underfunded and under-resourced, and Native American schools as well. So these inequities persist despite the mandate of Brown, and it requires us to develop new tools. Title VI was a phenomenal and still is a very powerful tool of enforcement, but as Damon already pointed out, it does not allow private practitioners like us to do the heavy work of holding government entities that receive federal funds to account. And we have to rely on the federal government, and the federal government has to be thoughtful about the cases it brings before these courts, and this Supreme Court in particular. So as we think about the unfinished business of the Civil Rights Act of 1964, we have to think about it in this holistic context and what can be done on the activism level, what can be done through litigation, what needs to be done through congressional reform, and what our federal government can do within those constraints. And I'm glad that we're having this discussion because this could not be a more critical time, because I don't think there's been a time in my lifetime where our rights have been so deeply under threat. And so this is a moment for renewed commitment and conviction, and to remember the power of what we were able to achieve 60 years ago and recognize that we still have that power today.
Thank you. Yeah, we will turn to talk more about some of the threats in a moment, but first I wanted to hear from John on the first question of sort of where we stand, both achievements and unmet promises.
Great, thank you very much. And one of the benefits of going last is that there's already so much good ground that has been covered. In terms of framing, actually for me, I always think about how forward-looking the Civil Rights Act was and how inspirational the Civil Rights Act was, right? And you've heard elements of it. The forward-looking part is oftentimes people, certainly in the general population, focus on the race aspect, right? And that's part of, at its core, what it was, right? But what's so forward-looking with respect to the activists that were involved, the African-American activists that were involved, was that it was more than that. It was ethnicity, it was religion, it was sex, it was national origin, right? And so how we weave those portions in, recognizing that those portions are part of our society that needed to be addressed as well, even at that time, was so important. Because if you think about, for us, the Asian American community, frankly, we were about 0.5% to 1% of the population back in 1960. So when the Civil Rights Act was passed, certainly we didn't have the power to speak for ourselves in many ways about sort of what our community needed. But yet we had leaders that were effectively speaking for us, that gave us that foundation that we were able to build from, whether it was using race, ethnicity, or national origin, right? At that time, if you think about sort of what it meant to have discrimination based on sex, frankly, if we're going to speak very boldly and candidly, that was typically about just a male-female binary. But thinking now how we've been able to use that to talk about gender equality makes such a big difference. And certainly with respect to religion, again, if you think about 1964, predominantly Christian society here in the United States, but now we're able to use it to talk about Islamophobia, to talk about how Muslims are being persecuted or profiled. So that is the forward-looking aspect of that law, of the law, and how we carry it to this day in all of our contemporary struggles that we have. Then why I say it's inspirational, literally think about what it inspired, right? It inspired the Voting Rights Act of 1965. It inspired the Fair Housing Act of 1968. Frankly, it also inspired the Immigration and Nationality Act of 1965 as well. So there are all of these components, not to mention Title IX coming later on. All of these components that certainly, again, it was being worked on at the time. I don't want to say that there was a direct line through all of these. But the fact that we got that act passed in 1964 really broke ground for all of these other advances that had happened. So as I reflect on it now, also it is about how inspirational, how forward-looking it is, and how we have yet to achieve those promises, right? And how we need to fulfill them. And to Janae's point about how oftentimes it feels like we're fighting against it. And the other thing I will name right now is how there are some that are trying to pit our communities against each other in trying to push back against the civil rights laws. Now, I recognize, like, I'm going to be very direct about it again, is there are some that are saying, well, we're trying to protect Asian Americans. I found it deeply, deeply offensive when Justice Alito, during the oral arguments for Harvard SFFA, said, well, what about Asian Americans? Don't they deserve to be protected? We are being protected through the Civil Rights Act. We were protected through Grutter and that line of affirmative action cases. And to use our community in that manner was deeply offensive. And so that's part of what we all need to continue to work on, is making sure that we send a loud and clear signal about how we stand united, what the difficulties are that are facing us, and how we see these laws as benefiting all of us, lifting all of us up in this period.
Thank you, John. So I want to turn back to Janae. Since this event today is focused on employment and education, I'm wondering if you could provide some advice or examples to employers and educational institutions about policies that concern you from the perspective of creating barriers to the Civil Rights Act's goal of equal opportunity.
Oh, thank you so much for that question. We all know that in the aftermath of the SFFA decision, we saw mass capitulation, we saw unilateral disarmament by the corporate sector, moving away from DEIA and moving backwards in their commitment to leverage what is our greatest strength, and that is our diversity. It was so counterintuitive, even from an economic perspective, to see the corporate sector recoil simply at the mere threat of this conservative extremist boogeyman that I could name, but I don't think I need to for you all. We immediately put out guidance for universities because the decision pertained specifically to universities. So the Legal Defense Fund, along with our allies, many of whom are on the stage, put out guidance to let universities know that even with the decision, that there was still work to do within the university context to ensure that we don't abandon the pipeline of diverse leadership for this country in higher education. And so that guidance is on our website. Similarly, earlier this year, we issued guidance in connection with the corporate sector and what businesses can do. And one of the things that we said immediately that all businesses should be doing is examining every single policy and practice pertaining to hiring and promotion and retention, and seeing whether any of those policies and practices has a disparate impact on any protected group. They can affirmatively do that. They should be doing that. That should have been routine even before SFFA, but it is now something that is necessary to counter what is likely to be an increase in hostile work environments, which we are already hearing about, which is an increase in the dismantling of important and critical programs to retain and enhance the work experience of people from different racial and ethnic backgrounds and other categorizations. And so we've asked employers to be deliberate and affirmative about these bottom line issues that not only are a moral imperative, but are a business imperative. We know that this goes to the bottom line of productivity, of innovation and creativity to ensure that you have a diverse workforce. So those are some basic ways in which the corporate sector can be proactive. They also need to be vocal about these issues. We hear about this through back channels or people saying we're still committed, but they're not willing to really embrace it openly. And we can't have that type of cowardice in this moment of threat. Corporate leaders have a role in our society and have our dollars in their pockets, profiting their top shareholders, and we should be demanding that they be vocal and they be unabashed about their commitment to what they know is important for their longevity and for their lucrative returns. So that's something that we're encouraging, and we hope that this bleeds beyond the corporate sector and that universities take up the charge as well.
Thank you. Sure, Damon, you want to add to that?
I could not agree with Janae more. So many companies who leverage their fiscal capital after George Floyd was murdered and Breonna Taylor was killed, we're calling on them, in the spirit of what Janae said, to leverage their reputational capital, to really stand with us, because this is not a time for retreat. But to the legal paradigm, building on Janae's remarks, you know, people talk about DEI as if it's the devil. DEI isn't working. I don't know about DEI. DEI is not a wish and an aspiration. DEI is a floor, not a ceiling. It is a way to satisfy your Title VII obligations, right? And so companies need to understand that devolution or dismantling of DEI, what it will breed. It will breed the opposite of diversity, the opposite of equity, the opposite of inclusion. It's exclusion. It's inequity. It's an abject lack of diversity. And so we call on them as critical friends, but we also may have to call them to court as well, right? Because we're going to need EEOC right there with us to enforce as well, because companies can't just say, we believe in diversity as a wish, and then not have any infrastructure in place to address it. So both inside and externally, we need them to stand with us now.
Thank you for that, Damon. And you alluded there to private and governmental partnerships. So that's a good segue for me to ask John, from your perspective, what are the most fruitful ways for government agencies like the EEOC, charged with enforcing the Civil Rights Act, and advocacy groups like yours to partner with and complement one another's efforts? And I also want to, if you have time, turn to Monica to ask about some of the challenges that you've observed that can impede those partnerships.
Sure, and one area that the partnerships really worked would be around data. Because part of this is we need more data. You know, if we're going to present court cases, if we're going to really model changes, even when we talk to corporations, as Damon and Janae are talking about, we also need that data to show them why this is an imperative, why this is so important. So one piece that was great that happened this year was what's called SPD 15, which is an executive order through OMB to change how we gather data in the federal agencies, so that we now disaggregate data. That's critical, especially for the Asian American community, because if you look at the Asian American community, oftentimes people think of us as a monolith, like a one-size-fits-all. Then it goes into a stereotype of us as a model minority or a stereotype of us as a perpetual foreigner. But the reality is that we need to understand who all of these different constituent groups are in order to tailor solutions for each of these groups. If you're talking about employment, for example, for Asian Americans, oftentimes at the entry level, I will admit, oftentimes the numbers look pretty good in terms of our representation, but then you trickle up and it looks terrible. Oftentimes, if you look at that data, I'm Chinese Americans. I will admit it, Chinese Americans represent pretty well. But if you look at Vietnamese Americans, Laotian Americans, Hmong Americans, it looks very, very different. So that's where having that data allows us to have a scalpel to address that through surgical means rather than trying to address it through a sledgehammer.
Great.
Sure.
Monica, do you want to talk about some of the other challenges you've experienced?
Sure. I'm gonna name some of the positives before I get to the challenges, because I think it's really important, and I want to call some other folks into the room. You know, because of people like Chair Berrien, because of people like Commissioner Barker, who was willing to really take a hard look at the Youth at Work program to figure out how to reach underserved youth. When you look at folks like David Lopez and Linda Lee, and so many. I'm naming people who are part of the EEOC who have done such hard work over the years, and to the earlier panel, have gone unnamed and unrecognized and need to be recognized. And these are some of the critical partners who we've had the opportunity to work with over the 20 plus years that I've been doing this work. Why are these partnerships so important? Particularly when we're talking about immigrant workers on the ground who are in low-paid jobs, who are afraid of government, who are afraid of coming forward to get help, even though they're experiencing both economic and sexual exploitation. We as organizations on the ground, as organizers, as activists, as advocates, we are the bridge between the government and the community.
Yeah.
And we are able to create the space so that the community feels like they can access the protections that are being afforded under the Civil Rights Act. And so those important partnerships must continue, like the REACH initiative, which Commissioner Kodegal has been leading. That is so important because its main objective is to ensure that people are the hardest to reach actually understand what is the EEOC, what does it do, and how do we actually deliver on the promise of the Civil Rights Act. So those are the positives. I think the biggest challenge, frankly, as someone who's been on the ground doing this work for a long time, Congress needs to fund this work. Congress needs to fund these agencies. We need more investigators. We need more people in the field. We need to make sure that people are not being pulled in so many different directions that they cannot do the meaningful work that needs to happen with the limited resources. That includes language access. We need to ensure that there are the right interpreters and information translated, et cetera. So that I would say is a huge obstacle. I would say the other is folks working with the government agencies need to see us on the ground as true partners in the work and understand that we are the bridge between the community and the government. And it is only gonna work that way if we see each other as true partners in the work. And so that is my invitation on this anniversary. Let's figure out how we're gonna continue to roll up our sleeves together to really deliver on this promise.
Great. Well, I think we were getting our warning that time is short, so I will just ask one more question to you all, and that is, if you had a magic wand, or could go back to the text of the Civil Rights Act with what you know now in light of the events of the past 60 years, what one change would you make, or what one issue would you address, either that you feel that the statute hasn't, there's a gap in the text that doesn't meet the modern needs of the 21st century, or perhaps to address a new or emerging threat that is now on our radar screen that wasn't on our radar screen back in 1964. And I'll turn that first to you, Damon.
Thank you, Carla. I will not concede a gap in the text. Because I want aggressive enforcement by every possible agency on the following: on digital discrimination. It's not even the battlefront of the future, it's the battlefront of now. Between algorithmic bias and artificial intelligence, we've litigated these issues at the Lawyers Committee about how it's been used in elections, how it's been used to promote mis and disinformation. The fact is, if you used a toaster to make breakfast this morning, that toaster is more regulated than AI. Period. And the lawyers in the room, which most of you know, that when you're talking about products liability like toaster, that's strict liability, right? We don't have anything remotely like that when it comes to AI. And so we actually rolled out in December what we call the Online Civil Rights Act, which will provide a duty of care, which would give a private right of action to sue, which would also have an anti-discrimination provision as an affirmative, and also require auditing, kind of like environmental impact assessments before AI tools are released. But without conceding any gaps, we want to see aggressive enforcement. The internet and the digital landscape are the public accommodations of today and tomorrow. So that means to me that Title II of the Civil Rights Act should be aggressively enforced, and if not expanded, at least applied to that digital landscape, because we know that AI is not the enemy, but it can be a force multiplier for racial and other forms of discrimination, and that's what we must ensure does not happen.
I agree with you. Let's name the opportunities for evolution. We need to revisit the threshold. That is one I'm sticking with. I also think we need to look at the definitions. We just last week observed the 5-year anniversary of Convention 190, which is the Convention on the Elimination of Gender-Based Violence and Harassment in the World of Work. The United States has not ratified, but we are adopting the framework, and many of us on the ground are pushing for the adoption of the framework, and hopefully one day we will ratify as a nation. But this terminology around the world of work, our understanding of who is a working person in this country, work has evolved. We all know that. The way we work, where we work, how we work, it has evolved. And so we need to continue to push to ensure that the language that is currently codified, that there is an adaptation or an evolution of the language as we understand it in its application. And the last thing I would say is that I want to commend the EEOC, because what I have seen over time is that the EEOC has been attempting to be as flexible as possible in light of some of the very difficult changing circumstances. And in particular, I think the EEOC did an incredible job in its response to COVID-19 and calling out the way that people were being impacted, people with disabilities, caregivers, how people in particular industries were being harmed because of the COVID-19 and who was being exposed. That kind of adaptability and flexibility and understanding that we have to give ourselves enough room to adapt ourselves and the way that we're doing our work to changing situations that none of us could ever have observed. So that would be the one thing that I would call on us on to do, is to continue to be flexible and adaptable in the face of whatever is happening in the world in order to be able to ensure that people can get justice under the law.
Great. Thank you, Monica.
Yeah, I agree that our Civil Rights Act of 1964 has nearly everything we need to solve the problems of today. The problem is how it has been interpreted. And so I fully co-sign the idea that the language itself doesn't need to be expanded. If I had my druthers, I would say we need an irreversible private right of action under Title VI, full stop. We also need the interventions that Damon mentioned about algorithmic bias and recognizing it as part of the apparatus of discrimination that the Civil Rights Act of 1964 addresses. But the one thing that I think also needs to be made abundantly clear, and that is that efforts to remedy past and current discrimination are not reverse discrimination, period. The Civil Rights Act needs to be extraordinarily clear about that there is a separate effort to remedy discrimination that is not the focus of the civil rights statutes that were meant to protect categories of individuals who suffered historical discrimination and continue to feel the effects of it and continue to experience contemporary discrimination.
Thank you.
Again, I co-sign everything. I think for me, right, it is about how do we modernize the Civil Rights Act to make sure that people today recognize its relevance. Because I think sometimes when you talk to the general public, they say, oh, that was passed in the 1960s. We don't really need it. Or like, we've progressed beyond that, right? That's sort of how some people characterize some of the civil rights legislation of the 1960s. And so to me, part of this is, and the EEOC has done this, the U.S. Commission on Civil Rights have done this, is to continue to hold hearings, continue to hold oversight, continue to hold fact-finding pieces to demonstrate that the ills that existed in 1964 still continue to exist today. And that is why the legislation that was passed in 1964 would need to be passed again today, right? And so, and part of this is the modernization in terms of talking about in terms of AI, talking about in terms of in technology, how our communities are getting left behind and all of that. But to bring that conversation so that people understand we're not fighting yesterday's battles, or maybe properly said, maybe we are fighting yesterday's battles because those battles aren't finished, right? And that is why we need to continue along these lines. That is why all of us, the government as well right now, is committed to the work that we do.
Thank you all for that call to action and for energizing all of us to rededicate ourselves to the work ahead, and for sharing all of your wisdom and perspectives with us. And I think that concludes our portion of this event, and thank you so much for all of your contributions.
Thank you. Huge thank you to Carla Gilbride, Damon Hewitt, Monica Ramirez, Janae Nelson, and John Yang for that outstanding discussion. Let's give them another round of applause. They gave us a lot to think about how we take the promise of the Civil Rights Act and bring it up to our current times to address the pressing problems that we face today. I want to thank you all for coming today, for staying with the whole program. I know we ran a little bit late. I want to in particular thank the EEOC for its partnership and to the National Archives, and thank you for your partnership in making today's program possible. So when he signed the Civil Rights Act on July 2nd, 1964, President Johnson said this to the American people. He said, "The Civil Rights Act is a challenge to all of us to go to work in our communities and our states, in our homes and in our hearts, to eliminate the last vestiges of injustice in our beloved country." So tonight I urge every public official, every religious leader, every American to join in the effort to bring justice and hope to all of our people and bring peace to our land. So as we leave today and we think about all of the important issues that were covered with respect to the Civil Rights Act of 1964, where we are today, what challenges we face going forward, let's get to work and keep fulfilling its promise for the future. Thank you.